All right, for all of you just patching in here, we'll get started in about 30 seconds. So if you just bear with us as we get all of the technical logistics taken care of, we'll get started here in just a second. All right, thank you everyone for joining us this afternoon. My name is Chris Koopman. I'm the Executive Director here at the Center for Growth and Opportunity at Utah State University. And I know many of you were expecting to meet with us in person this spring across the country, but given current circumstances, we weren't able to do that. So I'm glad you all chose to join us this afternoon. While I'm sure you all have many other Zoom calls and group chats that you could be a part of, I'm glad you chose to be a part of ours. And again, this is the first of many conversations that we hope to have in real time. So hopefully as these conversations progress, we'll continue to do Zoom calls with many of our experts and faculty partners. And as soon as it's possible, we hope to join you all soon and have these conversations as we planned in person. So I want to get right to the topic of our conversation today, and that is the intersection between antitrust, tech platforms, and free speech. And I really want to set this up by talking about three things that I think all of us have heard recently. The first of which being just general calls to break up big tech companies. I think you can't read anything in the news or watch anything on TV about tech companies without hearing some call for these companies to be broken up because they're, quote, too big. The second one is increasing concern from both sides of the political spectrum over bias. We've seen controversies arise over the past few months and years about content moderation decisions or decisions made by these platforms about what can and should be hosted on their platforms and what should not. And we've seen both folks from the left and the right increasing their accusations of bias against these companies. And then third, and perhaps most important right now, is the increased attention from state AGs. You have almost every state in the country at this point, attorneys general, focusing on these tech platforms and investigating them in some form or fashion. And I want to talk about all three of those together today. And we're joined by two esteemed panelists that many of you, I'm sure, all know, but I'll just give them a quick introduction for those of you who haven't been introduced to them before. Our first panelist is Neil Chilson. Neil is a senior research fellow for tech and innovation at the Koch Institute, where he guides the Institute's ongoing efforts to promote digital free speech, free association, and fostering a culture that welcomes innovation as the best way to both improve individual and societal well-being. And before he joined CKI, Neil was the chief technologist at the FTC and an advisor to acting FTC chairwoman, Maureen Olhausen. We're also joined by Casey Mattox, the vice president for legal and judicial strategy at Americans for Prosperity. And he's also a senior fellow for free speech at the Koch Institute. And in these roles, he advocates for a legal system that both respects the rule of law and protects individual liberty. And he has a wealth of experience in this space on free speech. For nearly 2 decades, he's worked to defend the First Amendment rights of students, faculty, families, healthcare workers, religious organizations, and he's represented these parties in federal trials, appellate courts across the country, including the Supreme Court of the United States. So I'm really excited to have both of them join us today for this conversation. And I just want to jump right into the first thing I mentioned. Casey and Neil, feel free to answer in whichever order you want to, but we've seen, as I said, increased accusations of bias from both ends of the political spectrum. And just, I'll ask you guys simply, are social media companies biased, and should that matter?
Well, I think social media companies are run by human beings. And so I think it's inevitable that there is going to be some bias in any algorithm, some bias in the way that people review content policies. I think that it shouldn't surprise us that it occurs, right? We all have bias, and I think those of us who are advocating for policies that are not, attempting to treat tech companies as the villain that some would like to paint them as. I think it's important for us to recognize that that's reality, right? I mean, there's going to be there are clearly going to be examples where tech companies have made the wrong calls, and they publicly admit that fact. So it shouldn't surprise us, I guess, that there are individual instances. But I think we have to view that within the larger context that there are hundreds of billions of pieces of content flowing through these entities. And that's usually what gets missed in that conversation, is that we are all aware of the individual stories of either ourselves or people we know who've gotten the pop-up from Facebook or from Twitter that either tells us that we're in Twitter jail or that that there is something is in violation of a content policy or something like that. But that's usually in the context of many years where someone can post and probably not have that circumstance actually happen to them. I don't know if Neil, if you want to add anything further there.
Yeah, I think the only thing I'd add there is that even even if you have your timeline on Facebook, completely just sorted by when something was posted, that is a form of bias, right? That's what we call a recency bias. And so even when we're talking about algorithms, there is no neutral in how you might show content to somebody. And so we need to think about like how are we choosing, how are we judging such things, and what is fair and what is possible when we're thinking about content online.
Yeah, I think the other point I would make here too is that interestingly, everyone thinks that there's bias, both left and right. Usually one of the points we make in our paper that Neil has dropped into the chat is that usually the other side is unaware of the claims of bias against the other side. So a lot of people on the right, for example, would be surprised to find out that there are people on the left who are confident that Facebook, Twitter are actually tools of the right that are out to censor people on the left, and have examples that they would point to that end. Because we tend to hear our own side much more than the other side, and are unaware of that, those charges of bias flow both directions.
Yeah, before I jump in with a follow-up, I just want to throw something out to the group. I should have mentioned it sooner. At the bottom of your screen, you'll see a Q&A button. If you have questions for the panelists, I'd love for this to be a conversation among all of us and not just Neil, Casey, and I. If you do have questions, feel free to drop that into the Q&A, and we'll get to it as quick as we can. I'll also mention that Parker Jeppesen, who many of you know and has been your point of contact, is on the call as well. And he can handle bringing you up on screen and getting you involved in the conversation if it requires it. And in addition to that, if you have any logistical problems, as I'm seeing some people ask about the Q&A function, if you have any logistical problems, be sure to email Parker at parker@thecgo.org, and he can make sure to resolve your issues. So let's jump into a quick follow-up here, and maybe an intersection of sort of these are human companies enforcing whether they mean to or not a particular point of view, and now they're really large. Should we care, and should it matter how big these companies are, given the fact that they are in fact enforcing a particular point of view, even if it's just a recency bias, as you said? Should the size of the company matter in terms of these questions of free speech?
Well, I mean, the way I would think about that question is the bigger a company is, and the way we're measuring big in most of these cases is the number of users, right? The bigger a company is, the more audiences it has to satisfy. And so I think what you see with the biggest companies is that they put a lot of resources into trying to basically make the average person on their platform happy. Or at the least upset. And so you can think about when you have a platform where people are speaking easier than ever before in all of human history, basically, where they can reach a mass audience, that's a really difficult challenge because you're trying to make everybody happy. So my sense is that the biggest platforms are the ones that spend the most time trying to strike a balance that makes the most people happy. And what that means is that ultimately it's not going to make everybody happy. There's going to be people who are upset with the balance that's struck, but there are market pressures on these companies to try to reach a happy medium.
Yeah, and I think the challenge, if we're all honest with ourselves, is, for those of us who, like myself, I'm a free speech advocate. That's certainly going to be my my bent, is to advocate for more and stronger speech protections. It would be difficult for any platform to satisfy me that it was speech protective enough. But I want it's not just that I want a very speech protective platform. Those exist, and for that matter, I could create a very speech protective platform. What I actually want is a speech protective platform that also gives me access to a wide audience. And I will often state that as, a preference for, I want, a platform that protects free speech. But as we point out in the paper, Gab exists. That's the platform exists, and there are multiple other places like that, Reddit and other places where that are pretty broad with what someone can post. But what I want is the ability to say what I want to say and have an audience that will listen to what I'm saying. And that's where, Neil's point about how these platforms need to satisfy a broader array of people. Not everyone thinks like I do on First Amendment issues, right? And so I need to be able to for the platforms, they need to be able to think about what is going to reach that broader audience, which then means I have a choice to make. How much do I value making sure that my speech is going to be permitted on a platform versus the size of the audience that I want, the ability to speak to people who otherwise wouldn't hear what I have to say, the ability to interact, for example, with people in the media and entertainers who I otherwise wouldn't have the opportunity to speak to, and may not move to a platform that I would prefer that would be a much more speech protective platform.
Yeah, and I also think it's important in terms of something that both of you have mentioned, is this idea of giving people a voice, right? In terms of encouraging a voice for people, there's probably been no other medium out there that's empowered more people to find audiences than social media platforms, both on the left and the right. I think that's something that oftentimes is lost in this conversation, is the fact that, someone like Diamonds and Silk wouldn't exist 30 years ago. They exist, but as a direct result of these platforms and their ability to connect content creators with audiences and find and interact with one another. But let's jump into maybe the first antitrust question, Neil. In these instances, let's say when let's say a person who's more who's, let's say, I don't know, a free speech absolutist, if you will, and thinks these companies shouldn't regulate any speech on their platforms at all. And so they're looking for an opportunity to encourage and support and protect free speech. Is antitrust that tool? Is antitrust an effective tool in supporting free speech rights?
I would say not directly, and our paper gets into this in quite a lot of detail. Right now it's as I already mentioned, it's never been easier to speak to a large audience or to find new or interesting ideas and voices than it is right now, and that comes with a lot of problems, as well as many benefits. But at core, these problems aren't caused by a lack of competition. Casey and I have already sort of talked about what they are caused by, which is ultimately we have social media users who have really different sets of preferences. At least there are subsets of the users who have really different preferences. There might be a lot of average everyday people who basically use Facebook to share cat pictures, and they don't have these strong preferences, but there are subsets who have really different preferences. And so you can, the example I use in the paper, no matter the number of competitors, you're not going to be able to design a soda that perfectly satisfies both, Coke fans and Pepsi fans, right? So when you have diametrically opposed consumer opinions on something, adding more competitors to the market doesn't solve that problem. especially because people want to be able to be on the biggest platforms that they can have. And we've, there's actually dozens of social media platforms. Casey mentioned a couple, but the 3 or 4 that have a really large number of users, it's because these platforms provide a mix of services that satisfy most people enough. And the best explanation here isn't that there's a lack of competition, but there's directly conflicting visions about what is good. And the companies basically have to split the baby, and they don't satisfy everyone. And, because it's not a lack of competition that's the problem, current antitrust law is not well suited to solve it. Because what antitrust law is designed to do is to address competition problems. It's a powerful tool, but it's not intended or created or well suited to solve every single social problem that might be out there.
So then what's the danger of using antitrust in this way? If it's an ill-suited tool, sometimes you can use ill-suited tools to get the job done, and it's just a little messier than ideal. But what's the downside risk of using this tool to advance free speech principles?
Well, I kind of think of it in 2 different ways. I mean, in some ways, you're right that sometimes you can use an ill-suited tool to do something that it's not really, you can use a screwdriver to pound a nail, maybe. Using antitrust for free speech is a bit more like using a jackhammer to brush your teeth. Like, it's probably not going to get your teeth clean, and it's probably going to cause a big mess in the meantime. Current law just doesn't reach the kinds of concerns that we're worried about in content moderation. So in order to use antitrust to reach some of these issues, I think you'd really have to change antitrust law, which means antitrust law applies across all industries. And so you're changing to deal with a problem in one industry, you'd be changing law that applies to all industries. And in many ways, we'd be going back to some of the solutions that have been offered that would make antitrust law maybe able to try to address these problems. Go back to some of the old ways that we did antitrust that just sort of have concerns about big is bad, or that we want to talk about political power when we're thinking about antitrust, and use all these different factors rather than approaching whether or not there's a harm to competition. I think, and we argue in the paper, that doing this sort of change to antitrust law would actually, not only would it not help free speech, it would actually provide a big tool that government could use to threaten speech. And we have plenty of examples in history of presidents in particular, but also competitors who used antitrust to threaten the speech of others. There's these great examples of Nixon having his advisors threaten the major broadcasters with antitrust lawsuits if they didn't do things like broadcast his daughter's wedding. Just the most manipulative things that you can think of. And because of antitrust is a powerful tool, the more arbitrary you make it, the more you raise the risk that it could actually become a threat to free speech.
And I think from the perspective of American audiences, for that matter, too, the current regime, and basically in the current system where Facebook particularly is one of the drivers, one of the largest companies where more people are using that platform, Facebook may fail at promoting voice, but voice has been one of the key driving forces behind Facebook since it was started. And Mark Zuckerberg has been very public about wanting to see that continue and wanting to lean in on that more. If you break Facebook up, whatever that means, and that's a whole separate conversation. What exactly would it look like to break up Facebook? Is it regional Facebooks? Is it like a A through D Facebook and an E through H Facebook? Like what does it look like to break it up? But if you broke Facebook up, the network effect, basically people are going to want that larger audience. People are going to migrate to whatever the platform is that gives them the opportunity for a broader audience. And if you break up the larger tech companies like Facebook and Google and Twitter, do you just end up then empowering companies that are not US-based companies that are not subject to the same pressures? And essentially, do we all end up on TikTok? And is TikTok then, or some other Chinese company that is not operating from the same free speech framework even, that we would think of in terms of wanting to see broader protection of expression on the platform and seeing that as a significant value, does that become the predominant platform? If that's the case, then you haven't advanced expression at all. All you've done is sort of empower a new platform that doesn't have those, many of those same values at all.
Yeah, and I think to your point about siloing or having these like mini regional or issue-based platforms is an interesting one. It's also one that Steve Del Bianco has brought up here in the chat, and that, it would be actually awful for both progressives and conservatives to find themselves on siloed platforms where they cannot communicate with people who are not exactly like them, increase interest in their particular points of view, and actually have meaningful conversations outside of people that they've already been converted. But I do think, just broadly speaking, Neil, just you sort of, nip around the edges of this, but the current conversation about using antitrust to advance these principles is really an unmooring of modern antitrust, right? It's pulling away sort of the foundational pieces that have made antitrust a productive tool, and sort of pulling it into a space where it becomes an unproductive tool. And in particular, I think that one of the things you mentioned was competition, right? Harm to competition. And two, we haven't talked about this yet, but consumer welfare, right? I think for the folks on the chat, and in particular, policymakers who are here, and we've heard this conversation recently about undoing the consumer welfare standard. Can you talk a bit about what that standard is and why it's so important in anchoring antitrust to focus on the right things rather than the wrong things?
Sure. So the consumer welfare standard is, I think there's sort of this idea sometimes that the consumer welfare standard is like some piece of language that somebody somewhere out there. What it really is a set of tools and presumptions that antitrust law has developed over several decades that say basically we're going to measure competitive good competition versus bad competition by its outcome for consumers. And you can see why this is really important, because in both cases, when you have like good justifiable competition, when you have two competitors who are going head to head and trying to win consumers, when one of them wins, the other one loses. And so there is a harm to competitors in good competition. And there's also a harm to competitors when a competitor is doing something bad. And so we want to think about like, how do we know good competition from bad competition? And the consensus has been in recent times that we're going to measure by the outcome for consumers. Now that's a challenging problem in many cases. It can be difficult to measure, but it's certainly easier to measure something like, is this good or bad for consumers than it is to measure something like, which company has more political power, right? Or how are we going to trade off, picking winners and losers? So it's more objective in that sense. It avoids this sort of balancing. The consumer welfare standard sort of avoids this balancing of different interests. So if I'm trying to say, well, I care about consumer welfare, but I also care about political power, and I also care about the size of competitors, what that means is if I go before a judge as a company, I have no idea which of those dimensions to argue on, and I have no idea. They can pick whatever decision they want, and they can probably find some evidence that meets one of those dimensions, and there's no principled way to balance between those different dimensions. And so what it means is we have a law that is much more subjective, that's much more arbitrary, and the consumer welfare standard gives us a single dimension to argue on, and it focuses on the ultimate outcome. It also helps align industry practices towards those that are the most economically efficient. And so I think the reason that people want to change this standard is that it gets in the way of them using antitrust law for purposes that they hope to achieve that are different than economic purposes, frankly. And so the question is, why are they choosing to do that through antitrust law rather than, other types of policy? And I think it's because antitrust is a big, attractive, powerful tool, but misusing that tool doesn't make a ton of sense to me. And so I do think the consumer welfare standard has done a really good job of focusing us on what at least the right approach. That's not to say the law is static. It's not. There's lots of debates in the antitrust bar about how do you measure consumer welfare? How might you consider different factors as affecting consumer welfare? There's lots of debates over the economics and the evidence, and that's appropriate. But at least we're all arguing about the same set of principles, the same goal. We all share the same goal, and that's been to the benefit of antitrust law.
I think the other point here, I mean, so much of what we've talked about so far has basically been policy reasons why using antitrust is the wrong answer. The other big point to make sure we don't miss here is that the First Amendment also speaks a lot to this, or very well may speak to a lot of this. While we're talking about the policy issues, the First Amendment restrains the government. It doesn't restrain Facebook. And the attempts to, by some litigators to try to apply the First Amendment to social media platforms have failed, and correctly so. So if, at least depending upon the contours of exactly what is proposed, and whatever it means to break up tech companies for this purpose, even where the law or the approach is not directly content discriminatory, if the purpose behind it is to impose content policies on these platforms that would regulate their expression, they are private companies. Now, will they sue? Would they sue the administration? Would they sue over something like that? That's perhaps a different question, and there are a lot of political reasons why they may choose not to challenge something like this. But there are serious First Amendment problems with just telling private companies that this is how you are going to be regulated and what expression you're going to permit on your platform. There's a long line of Supreme Court precedent, to the effect that compelled speech is a big problem. And compelled speech is a problem even when it's a very large tech company that's the one who you're compelling to allow people to speak on.
Yeah, and I think we've already talked a little bit, and Neil's mentioned the history of sort of the politicization of antitrust, and presidents from LBJ to Nixon, throughout the last century or so, there are these examples of what it looks like when antitrust becomes politicized. I want to talk a little bit about sort of the history of sort of compelled fairness or enforced fairness on the part of the government. We don't have to pretend to know what it would look like for the government to force fairness on platforms. We have some of this history. And Casey, can you talk a little bit about sort of how that turned out historically and what lessons we can draw from sort of the Fairness Doctrine in terms of how not to approach social media today?
Sure, and I think this basically gets to cases like Red Lion, the Tornicello case. And basically the answer is, at least with Red Lion, it's still technically not overturned. Most observers think that it's effectively overturned, and it's the kind of case that you don't want to have to rely upon to create new policy. Over the last 3 or 4 decades, the Supreme Court has become much more speech protective in its jurisprudence. And I think it would be difficult to imagine a case like Red Lion actually withstanding scrutiny today if it was up to the court, given, again, the chain of Supreme Court cases on compelled speech and compelled association, and even the movement there on commercial speech issues, where the court has become much more solicitous of the government's interest in regulating commercial speech. So I think there's I think what those, it creates a little bit of complexity because the cases still stand, or at least Red Lion still stands. But I think most who would look at the issues would basically say that this is not likely to be a strong precedent that the government should be relying upon for new regulations today. And largely rejected, by the way, especially on the right? It's been largely rejected by commentators on the right, by the Reagan administration and forward till now.
Yeah, actually, I just flagged that I shared a link in the chat to a great essay by Paul Matzko and John Samples that was just released, I think, yesterday or today, that is actually part of the same symposium that Casey and I's paper was, that looks at the Fairness Doctrine and the abuses of it. It has some great stories of how the Fairness Doctrine on broadcasters was abused for political purposes in many cases, frequently to the detriment of conservative voices. But it's not purely partisan abuse there. And when Reagan pulled it back in the 80s, it's no coincidence that conservative talk radio took off right at that time, in part because of the Fairness Doctrine was shutting that down. So government compelled fairness, it sounds, the word fairness sounds great, but it's a recipe for politicized government involvement in speech, and that's a real problem, as Casey's pointed out, under the law.
And it also, one of the challenges here too is, at least in Red Lion, you're talking about radio and TV frequencies where there is at least some argument for a limited amount of frequencies that can be had. Your radio only has a certain amount of numbers on the dial, right? And there is no 109 on your FM station, and so you're sort of limited there. With the internet, that's much less true. You can, any of us could create a web page today and build our own new thing. So that's one of the blessings of the internet. It also would seem to diminish the government's ability to be able to advocate for this sort of notion of the internet as a public resource that must be protected and shared.
Mm-hmm. Yeah, and real quick, I want to circle back to some of the First Amendment concerns that people are raising, and I think Diane Katz has raised this specifically, and she says there's no free speech obligation for private platforms, yet right. People are out there advocating for free speech obligations for private platforms. I don't want us to argue as straw men. So if you can sort of humor me here, Casey, can you perhaps make the Iron Man argument? What's the strongest argument that people are making for applying the First Amendment to these companies? And then let's unpack it in sort of why is that wrong? Like, why should we not be in the business of trying to apply the First Amendment to private platforms and private companies?
Sure, and I hate this question because I hate the argument that much, but
sorry.
Yeah, that's fine. And others can probably be much more fair than I will be, and can perhaps suggest other alternatives. But I think basically, cases like the Prager case, for example, sort of point to two sort of arguments. One is, well, but the platforms say that they are public forums. And so if they say they're public forums, then they must act like public forums. So it's sort of an estoppel argument, if you will. And actually, I guess I'll give three. The second is the argument I gave before, that it's sort of like broadcast platforms. This is that's kind of a public good. It's a public utility, and therefore that's how people all speak now. That's how expression happens. And so government has a role in making sure that the space for expression, which used to be the marketplace of ideas, the city park, has now moved online. And so government has a role in making sure that is protected in that context as well. And then the third, I guess, is the sort of, well, it's heavily regulated. And if it's heavily regulated, then there's sort of this, government and private are getting close. And since they are getting close to one another, then it sort of becomes government. And so maybe there are, Neil, if you have other kind of arguments that you've seen that you think are worth addressing, but I think those are basically the three, and I'm happy to, after we sort of set that up, happy to sort of pick apart.
I think those are the strongest ones. The sort of state-sponsored, or I think is kind of what you were talking about at the last part, that this is serves the function of a government, government function, and therefore must protect the rights of people as if it was a government. And So I think those are the strongest arguments. I don't think any of them is particularly strong, which is why these cases keep losing. So.
Yeah, and so basically, on the first, the notion that because they said we are a public forum, therefore the First Amendment applies. I can say that I am the king. That gives me no. I can't convert myself into the king by saying that I am the king. And public forum is sort of a loosely used term, right? People say that in a lot of contexts. That doesn't mean, I therefore think that the forum doctrine of the First Amendment, which has been a thing since the early 80s, is in fact applicable to me. That's I think not. I don't quite get how the estoppel sort of argument applies there. That because you've said it, then you're sort of subjected to the First Amendment. I think the regulation idea, that gets you into a pretty dangerous spot. If just because government starts regulating something, it effectively takes it over. First of all, that starts to reach a whole lot of private conduct if you think that way. There are a lot of businesses that are very much private businesses that have a lot of regulations. If you follow Crime a Day, there are a lot of things that a lot of businesses are told that if you do this or that in a slightly different way, then you're going to be, in jail for that. Well, okay. Well, does that suddenly mean that because the government is heavily regulating, how many peas can be in your, frozen peas, how many per pound or something, that therefore pea production becomes is now a kind of a public function. So I think that's problematic. And I'm forgetting maybe even now what the third third argument is. But I think as we said, it's basically these are pretty weak arguments in my view for any actual application of the First Amendment to these platforms. And frankly, from the concerns of people like me who have spent a lot of time advocating for freedom of expression for businesses in a broad context. I mean, you have cases like the Masterpiece Cake Shop case, obviously, that was at the Supreme Court recently. You've got the Little Sisters of the Poor. A lot of those cases, there are a lot of bad implications. If you think that that the private parties in those cases should win those cases, there are a lot of bad implications of those arguments for private parties sort of losing their expressive rights in those contexts.
So just to follow up real quick to this, not only are those arguments weak, but taking those arguments and running with them, they can in fact be dangerous to the future of the internet and these platforms. And I just want to touch on this real quick, Casey, if you can. So why wouldn't we want to apply the First Amendment to companies like Google or Facebook or others? What is the danger in enforcing First Amendment rights on these private platforms?
Yeah, I mean, the first problem you have is again, they have their own First Amendment rights. So to convert someone from a First Amendment protected entity to someone with First Amendment obligations, just because of the kind of service that they provide, because they provide a forum for expression. These are large companies who themselves, may decide that they they are more interested in facilitating expression. But frankly, if I am Mark Zuckerberg and I have spent billions and billions and billions of dollars building a platform, then yeah, I do have an interest in making sure that the thing that I have spent my life building is not used in ways that are directly contrary to very core beliefs that I would hold, right? Now you may sort of compromise a lot of that, right? And they are looking to facilitate a wide range of expression, but there's obviously some line that just about all of us would cross. We don't want to push people out of the market of creating a platform like this. I mean, there are also things that exist that are smaller, more niche platforms, like GodTube, for example. GodTube is basically a social media platform that exists for religious believers to share content online. At what point does GodTube become a public forum? Is there a sort of a magic number of users where after it crosses that line, then it actually becomes a First Amendment obligated organization to permit whatever content people want to share there. So I think there's a lot of downside risk, and frankly, it could encourage people to not bother trying to create, particularly platforms like that, and the more sort of unique platforms that it encourages them or would discourage them from being in this space if they risk having their own expression, what they're trying to do, basically overtaken and strangely censored, actually, by the First Amendment obligations that would be placed on them.
Yeah, I would also add that it could run the risk of stifling innovation, maybe not perhaps technological innovation, but policy innovation within these companies. So even today, we saw Facebook announce that the first 20 members of the new oversight board are now in existence, right? The oversight board is now happening, and that is a very different approach than, let's say, companies like Twitter have taken, or even Google or others have taken, and having a single policy for all of these companies where you were First Amendment obligated entities really undermines the ability for these companies to figure out how to engage in their own balancing of these principles that they hold to be important to them. I know you've talked about this a bit, Neil.
Yeah, one thing that's interesting about this this idea of applying, just the practical implication would be that the platforms that you want to go visit are now basically at the same standard as the guy who can stand in front of the state capitol, right? Is that the content that you are going to go back to platforms to see? These platforms are porn is protected by the First Amendment. You have lots of things that most of us don't want to spend our time, beheading videos are protected by the First Amendment. There's lots of things you don't want to spend your time looking at that are protected by the First Amendment. And it's hard to see how these platforms would sort of square the need to provide a market that's interesting and attractive to consumers with that particular obligation. But the Facebook board, I do think that oversight board is interesting. It's an attempt to provide some independent oversight and decision making that's outside of the business. We'll see how it goes. I mean, like you said, it's innovative. It's not been tried before. It's different from how other companies are doing it, and I think it shows. Back to our discussion around competition, it shows that there is pressure to do something in this space, to innovate in this space, and that companies are taking really different approaches. So to me, that suggests competition is alive and well in the social media platform when it comes to diversity of speech policies, and it'll be interesting to see how this plays out. And Mark in the Q&A, thanks for asking that. Yeah. Sorry.
Yeah, which is I mean, just to play off of Neil there, it's always interesting to me when I see people talk about censorship by big tech, because there is quite a wealth of speech policies online by different platforms. And so, it's not as if they are all speaking with the same voice, that the same sorts of content will be treated the same in every context. So, I think there's a competition, as Neil said, competition is already providing some answers here, and companies trying to move toward, address the concerns of one part of their audience or another, and that's a positive. So, I think Facebook is obviously attempting to recognizes that it wants to be seen as a platform that is promoting voice in the U.S. and internationally, and it's created this oversight board to try to help position it well, to be able to speak to that those who care about that issue. Not everybody has done that, so there's a clear distinction right there between how Facebook is approaching this and some of the other platforms are.
Yeah, so I want to pivot real quick. I know we have a lot of state policymakers on the call. We also have some folks who are involved pretty deeply in state level policy work. So for people thinking about this at a state level in the context of state attorneys general and the current push against these companies, from your perspectives, what's the one thing that state policymakers need to be considering in all of this as these investigations among their state AGs continue forward?
So what I would say is that state policymakers should think about, especially those in the legislature, they should think about what their role is in addressing needs that the market is presenting. I think they can think about that in two different ways. The first is, if antitrust isn't a good tool to solve problems that people are expressing, are there other tools that are better? Or does the legislature need to get involved and think about what they can do in this space? I'm not advocating any particular solutions, but I do think that it's important that legislators not let not just relegate their role to state AGs who are going to use the tool that they have, which is one of which is antitrust, to try to pursue the things that they think are politically viable. I think it's important that legislatures assert their role as a co-equal branch of government and think about how they might solve the problem. So that's how I would think about it. Grandstanding AGs is not the solution to everything. And legislators have a really important role.
I think I would just say, first, do no harm.
Perfect. Succinct. There you go. Okay, so we got a question just pop in here, and I think it's in response to our conversation from just a few minutes ago. And they ask, essentially, so what's the line on discrimination in private businesses? Can I not bake a cake for a certain person based on my own bias, or not serve someone in my restaurant because of my own bias? What's the difference between, let's say, restaurants and cake shops and Facebook? Yep.
Yeah, and I think the answer to that question is still being played out in the courts in a number of cases. But and like I said, I think there's going to be a difference in the arguments that Facebook is going to be willing to make versus a single cake shop operator are going to be willing to make. But that doesn't change the fact that they still have First Amendment rights at issue. And that policymakers shouldn't just be thinking about, what is the likelihood that X, Y, or Z company or individual is going to sue us over taking an action, but honestly, what are our obligations to the First Amendment rights of the entities that we would be addressing this against? So, basically, it's not a terribly satisfactory answer because the courts are still weighing this, but I mean, the cases that sort of set up for it, though, I think the idea of the government compelling a private entity to speak in a way that violates its conscience is problematic. Now, exactly what that case looks like with respect to a Facebook or a Twitter, we don't have that case in front of us, but I think broadly speaking, that should be a concern for legislators.
So let's real quick, let's put some flesh on these bones. So we've got sort of like in the abstract, but we do have real instances in which I think most people would agree that companies should be empowered to make content decisions. Let's say something like the Tide Pod Challenge, or let's say speech that quite frankly, you know, as a company owner, you don't want to support. Let's say someone's saying that, you know, drinking bleach will cure you of COVID. And you've seen a lot of these decisions made by companies in recent months about health misinformation being taken down. What if in a world in which the First Amendment were applied to these companies, would a company like Facebook have the ability to take down speech that isn't just, you know, violating their own personal principles, but may in fact lead to harm by other users?
Yeah, I think this question illustrates exactly the challenge that these companies are faced with. Any of us can imagine that if, you know, on one hand, if you were told you must post a video that is giving people not just bad health advice, kind of generally bad health advice, but advice that if somebody follows this, they're going to die. And I don't want that to happen, right, on my platform. That you wouldn't want to do that, right? You would not want to share that information. And so if you end up with rules that are basically ordering companies to allow that, I think that's, you know, particularly concerning. At the same time, you know, one of the concerns that I've had with the way this has been addressed in the COVID context is that a lot of the you know, Facebook and others have largely looked toward government guidance for what is the correct information. Now, in a pre-COVID world, I think most of us would look at that and said, well, that's the sensible way to do this. Because if, you know, is something poison or not? Well, the you know, poison control number will tell you that, and exactly how to, you know, what to do in case it is, right? So if someone is sharing, you know, basically weirdly enough, it's become a political question. If somebody had told me in January that, you know, well, what if someone is trying to share a video that says you should drink bleach, and Facebook says, you know, well, what does the poison control say? That sounds like a different thing. It sounds a little more challenging now for Facebook to say, well, we rely upon government guidance, and that is sort of the arbiter of truth. But the only reason for that is, frankly, that we've all seen examples over the last couple of months where government was wildly wrong about what was the correct answer, right? Masks or whatever else. You know, information from government has not been particularly trustworthy. And so making it the source of information is challenging. But all that to say, it just speaks to the challenge, I think, that these companies are under, trying to figure out even something very basic like, you know, things that could legitimately hurt or kill people, and, you know, who you should rely upon for the scientific information.
Mm-hmm. Yeah, and I know that, you know, some of this also gets into the, you know, Section 230 conversations about distribution versus content creation. And, you know, we just had a question in the chat here about, would a platform be protected from liability for the danger caused by information on their platform if we were in a situation in which the First Amendment was applied to these platforms? Those are sticky questions. I think it really gets to the heart of the issue here, is that, you know, going this particular route, applying the First Amendment or using antitrust to break up these companies, is short-sighted in its application, and really does little to advance, I think, the principles that most of us are talking about here today in terms of both voice and encouraging entrepreneurship and competition and innovation within this industry. So we only have a few minutes left here, and so I just one last question to Neil and Casey, unless anyone has something they want to throw in the Q&A at the last minute. But for Neil and Casey, what's the takeaway here? You know, what's, you know, to put a bow on this conversation in terms of antitrust, Neil, what's the one line you want people to remember when we push end call on this conversation today? And the same goes for you, Casey, in the First Amendment.
So my takeaway would be that these concerns about free expression aren't caused by a lack of competition. So antitrust is the wrong tool. And in fact, if you use antitrust to try to address these free speech concerns, you risk actually threatening free speech rather than supporting it.
Yeah, I think I would just say that, and this is predominantly aimed at those who are concerned more about the bad content online and would advocate for policies to be more restrictive. I think there is certainly a lot of that, right? I mean, these online platforms have a lot of expression that we would disagree with, you would strongly disagree with, not want your children to see, not want to see yourself. But the reality is there's bad speech everywhere. It's just that the platforms make it much more visible. They hold a mirror up to us and we see ourselves in those platforms. And sometimes the things that we say online are not particularly happy with what we have said online, and it's sort of out there for the world. But it shouldn't surprise us, I guess, that these platforms have that sort of content, but squelching it online, I think, is or trying to apply policies in a way that would make them more speech restrictive, I think doesn't actually solve a problem. It makes it sort of drives it underground, makes it quieter, but it doesn't actually address kind of the core issue.
Awesome. So we just have a few moments here. I just want to wrap up real quick. Thank you both, Neil and Casey, for being on the call today and sharing all this information from your research in the paper that you published recently. And for those of you on the call, I'd be happy to share all of the links that Neil and Casey have referenced or talked about today. The best way to get in touch with me or Parker in the future if you have questions is parker@thecgo.org or chris@thecgo.org. And again, this is the first of many conversations that we'll be having over the next several months as we unpack a lot of these issues. And if we can be a resource here at the CGO, please reach out to us. And hopefully as soon as all of this subsides here in the future, we can once again be with you all in your states and continue these conversations in person. So again, thank you for the conversation, Neil and Casey, and for all of you joining us, and we'll be in touch soon.
Thanks for having us. It's great.